This will be chapter 12. Do what you need to know about. What do you need to know about the law? And this will be a longer lecture than usual. Lots of information. I can't make you proficient in this area, but I want you to have some awareness entering the field of teaching of some of the things, some of the laws, where they came from, where they're going. And so please read this chapter. Please study this information. Please prepare yourself in this area for future. You'll get some veganisms here, some of my attitudes and approaches here, but some pretty insightful stuff and stuff that'll be important to you. Let's look at chapter 12 about the law. Well, chapter 12 about the law, and as you see the picture here, the image, you can see some of the things start to come into play, like the screening and stuff of people coming in. And let's do this. If you haven't done this, stop this now. Yeah, stop this video and go and watch the video from chapter 12 about zero tolerance in schools. Then come back to this. Okay, I'll wait. Go ahead. Shut this off. Okay, chapter 12 and knowing the law. Legal issues in education are complex, controversial, big time controversial, and mostly because of the change, because they involve a conflict between the rights of individuals such as parents, students, parents with the rights of school district to establish a productive and safe environment. And then different than the rest of the world, you have rights as a student up to a point that it doesn't interfere with this educational environment. And that's hard to understand. We'll talk about a lot of things that conflict with this. The other thing, of course, it makes it very conflicting is the parents' rights compared to the students' rights and stuff. So lots of stuff here, lots of stuff to know, but it's confusing and conflicting. Here's the focus questions. Why do today's teachers need to be familiar with the legal context? Which laws may extend constitutional rights and citizens? Which due process protections do students enjoy? And how are general patterns of court decision regarding teachers' constitutional right important to teachers today? And hopefully we'll try and answer some of those. When do the basic legal obligations of teachers supersede their rights? And that's an interesting concept also. And what are the legal issues associated with teacher certification, continuing ed, and tenure? And I want you to certainly know those things after this. So this is how your text is laid out, is what you need to know. And then here in two parts, first the learner's rights and then the teacher's rights. And that's how we'll break this down. And is it a right or a privilege? What about due process? What are those basic rights? But for you as the teacher, I talk about certification, employment contracts, continuing employment and tenure, just your general rights, and then your legal obligations. And this is how chapter 12 is laid out. Well, first of all, teachers have professional responsibility to know the basics of the law and the implications they hold. And that's you. Please don't leave here and go into this field without some of this understanding. Start with the teaching contract. A lot of you don't know anything about a teaching contract, and like anything, ignorance is no excuse. That will never be your reason in court, as you didn't know. In education are complex and controversial. Yeah. Okay. Learners. First, let's do learners' rights. A legal doctrine known as in loco parentis. Have you heard of that? It really governs that relationship between the teachers and learners. It was thought that when you sent your kids to school, the teachers now took the place of parents. In loco parente. That's a term that you'll want to use kind of loosely, that you'll impress some principal when you're interviewing sometime, that you know what in loco parente is. And various court decisions have extended to students the same kinds of legal protections that adult citizens have. And again, the emphasis is various, because not always. Is education a right or privilege? Well, for most of history, education has been viewed as a privilege, and the courts were generally reluctant to substitute their judgment to those of school officials. Meaning, If the school thought that the student should be expelled, the court said, gee, they would know. And school officials had great latitude in making and implementing school policies and rules because of that. Now I'll take you back here for the most of its history. Okay. So is education a right or a privilege? Well, it became apparent that literacy and education are critical to individuals' economic well-being. And denying the individual an education was seen as denying the right to economic and social advancement. Now, how did we figure that out? That we figured out that literacy and education are civil rights and have to do with economic well-being. Well, for one thing, we go up to our prisons and see that about 80% of the people incarcerated in the prisons are undereducated. And so we also see that people that earn the lowest wages are undereducated. And what does it mean to us? Why is it? What skin do we have in economic well-being? Well, anybody that isn't gainfully employed or employed, to a certain level, are supported by us as taxpayers. So that's where it comes that we all have a stake in seeing that people are all educated. Social circumstances also had an impact. Okay. Social circumstances. During the course of fighting in Vietnam, many individuals questioned the wisdom of the government. And not that this hadn't happened before, but this was the first time it was really overt. I remember some of this. This was during the 60s, and I was born in the 60s. But that was the first two. Then we said, now, if the people running the government and declaring war in Vietnam can be questioned, how about even those managing the schools? And this was the first time in the 60s that it really became an issue of challenging school authority and school management and intuition and those types of things. So that's where the social part then became part of it. Social consciousness started to question those things. And then came in 1969, really is where this came to a head, is Tinker versus Des Moines Independent School District. Now again, this is one that we've studied before, but you will need to know this from heretofore. You'll have to know what Tinker versus Des Moines is about. This is referred to many times. You're going to see this on tests. You're going to be asked about this in job interviews. You'll want to be informed in this about Tinker versus Des Moines. This is on page 316. In this case, a group of learners in the Des Moines, Iowa public schools wore black armbands to protest the United States' involvement in Vietnam. When school officials heard of this planned protest, they passed a rule prohibiting the wearing of armbands. When some students refused to remove them, they were suspended from school. A couple of the students challenged this action, and the case eventually reached the Supreme Court. The Supreme Court ruled that once states established public schools, individuals have a property right to the educational services the schools provide. Okay, so they have a property right. They have a right to this service. The court pointed out that neither students nor teachers leave their constitutional rights at the schoolhouse door. This had enormous implications that it ruled that the students did enjoy the protections of the Constitution, and, like other rights, could not be denied unless specific process or of due process was followed. This ruling placed the legal relationship between schools and students in a whole new context and open to challenge many traditional school policies and actions. Okay. I wish this was the end of the story, but it's not. Eventually the court goes on to rule and say, unless it's disruptive. Okay. But this had to do with wearing black armbands. Tinker versus Des Moines had to do with wearing black armbands in protest. And where the school got in trouble was this, is where the school went back retroactively and passed. They hear there's this protest coming, so they quickly then pass a law prohibiting it. Now again, it's one of those things. I think had they done nothing, nothing would have happened. The kids would have wore their armbands, and that would have been that. But an overzealous school are sure that the place would never be the same, so they passed a law. Okay. So learners' rights and responsibilities. What do you think? Should schooling be defined as a privilege so that professional educators can more aggressively respond to problems without being concerned about legal rights? Please respond to this. Number one. And how do you respond to the contention that poor discipline is related to the erosion of the authority of teachers and administrators? Please respond to this. Number 2. Okay, let's look at due process, and this is another term, like in local parente, that you'll want to understand and have a working knowledge of. The 14th Amendment of the United States Constitution outlines the principles of due process. You've heard of this, right? Due process? Well, to be entitled to due process, individuals must show that they have been deprived of either a liberty right or a property right. Okay, so what are those things? Well, property right or liberty right. Education is property, reputation is liberty. So to be entitled to due process, to challenge someone, which of these were you denied? Okay, substantive component of this is you must have written rules and a hearing. This is part of due process. You must have something written that they've broken. You know, if you're going to deprive me of education or my reputation, you must have some rule that I have broken, a written one, and that I am entitled to a hearing. Okay, here's what you say about due process, the 14th Amendment. You have to state what right you've been deprived of, and there has to be written rules and a hearing. Okay. Then the procedural component of this is student must know these rules, and they have a right to have a lawyer and defend themselves. Okay, this is one big egg. Now let me make it an egg. Here it is in one egg is what the due process is about. Which right were you denied, property or liberty? And two components, substantive says they must be written rules and you're entitled to a hearing. Procedural component says that you must know the rules. I can't be held accountable for rules I don't know. And I have a right to a lawyer and defend myself. And like know the rules, that's why we now have student handbooks. In my time, it was unheard of. Now there's student handbooks that in there has all the rules. It's in reaction to this, having the 14th Amendment, the due process right in school. So, 1, 2, 3 things, 4 things here that you need to know about due process. Okay, impose such thing as this. The individuals are not to be disciplined on the basis of unwritten rules or laws. Why is that? Well, we have this rule about not walking on the grass. Now, I know it's not written any place, but you should know you don't walk on the grass, therefore you're punished. Okay, that's an unwritten rule, and they're not to be disciplined for those things. Better have that in your handbook. Rules and laws are not to be vague. Individuals are entitled to a hearing before an impartial body. And vague schools have worked long and hard, spent a lot of money on lawyers writing rules. This is interesting too. The identity of the witness must be revealed. Whoever's charging you with something. Decisions must be supported by substantial evidence, like anything. What this means for teachers in schools is that rules governing learner behavior must be distributed in writing to learners and their parents. And again, like I say, this is now the handbook that everybody gets. Gets a sticker each year. And whenever a learner is accused of that rule infraction, they might result in the loss of a right. The charges must be provided in writing. There's a little nugget for you, but this isn't you anymore. You're not the student, you're the teacher. And so you're not saying you need yours provided in writing. You're saying a student in your school that's being charged with something gets to have that provided to them in writing. Notice must be given a sufficient time for the learner and his or her representative to prepare a defense. And again, they can ask for more time. It becomes like a court of law. That's this whole thing. With due process, it becomes like a court hearing, even though it'll probably happen in school. A hearing must be held in a timely manner, usually within 2 weeks. Individuals have a right to present a defense and to introduce evidence. Individual may have a right to legal counsel and to confront a witness. These provisions have applied differently according to the circumstances and seriousness of the institutions. Must be based on evidence presented. I know one I saw was in a local school here. The kid was accused of having marijuana. Actually, they saw it in his pocket, something in his pocket. His defense he was allowed to present was it was lint in his pocket, not marijuana. Well, needless to say, he sank and burned and was kicked out of school and those types of things. But he was entitled to that defense and took it to the full extent when he was suspended for, they have a zero tolerance thing. That was his defense, and took it to the extent before he was expelled. So let's look at these learners' rights and responsibilities. What are those basic rights of students? Well, there's the freedom of expression, freedom of conscience, freedom from unreasonable search, some right to privacy, and special rights for those special ed kids. We've talked a little bit before, but we'll touch that again. So these 5 things, you'll have to know something about all 5 of these. Okay, let's look at freedom of expression. What was this one about? Tinker versus Des Moines? Anyone? Anyone? Oh, that's right, the black armbands. Free expression of civil liberties in school. And it can't be disruptive, and this is where that changed. The courts found, hey, you have the same, you have these constitutional rights as anybody else, but schools enjoy a special protection that others don't, other areas don't, because they're challenged to run an educational facility, an educational system. So therefore, you have all these rights until it becomes disruptive. Now, when I was teaching middle school, here was one thing that we were really vigilant about, was the fluorescent colored hair. If somebody came to school with fluorescent colored hair, they stood in the bathroom in the principal's office for as long as it took and shampooed it out. And we brought a case of shampoo, and we had kids stand there an hour at a time shampooing over and over to get the fluorescent color out. Why? What would fluorescent hair hurt? Well, it's middle school. We had 1,000 kids there. One day it's 1, the next day it's 580. And it becomes very disruptive. So we had different things. No marijuana, cigarettes, no beer cans or anything like that. We had a series of things, of shirts they had to put on over it, or different things. But middle school, more than any place, that it is like fire. If it starts, it goes crazy. And so you're trying to protect the place so it's not disruptive. Now, how disruptive are those things? That's usually the judgment of the school administrator and you as the teacher. You can be critical, and again, it's such a fine line between being critical and not being disruptive. It may or may not be. That's what we determined, that fluorescent colored hair was disruptive. The school back in Tinker versus Des Moines says the armbands were disruptive to the school. Well, I will tell you, back then, all protests were disruptive. That's what they were about. Can't censor it if it's disruptive. And again, that's where it gets. In general, the courts have ruled that student expression cannot be prohibited simply to avoid discomfort or unpopular viewpoints that might be contrary to those of school officials. Unless what? Right, unless it's considered disruptive. And of course, the school has that latitude to say anything you say that's causes is discomfortable or unpopular could be disruptive. So you can see, I've tried to clear this up, but it's not clear at all. But here's the litmus: is it disruptive? These other things come into play. Freedom of expression for a student. How about this on page 320? Are dress codes a violation of student rights? Attendance policy a violation of student rights? Let's make this for you to respond number 3 and number 4 in your notes, please. How about freedom of conscience? We had freedom of expression, freedom of conscience. Well, what if you object to the curriculum? Here's what you got. Okay, if it's religious or moral objections. Huh? How about this? Saluting the flag can refuse on religious or moral beliefs. Now, I can't quite get around this in this country, that we'd say it's okay not to salute the flag based on religious moral beliefs, but that's where we're at. And you, as a teacher, don't get to change this. But here's those objective things like sex ed or dancing, playing cards, watching a movie, or creationism or evolution. Okay, so if you object on one of these grounds, you can be excused from this. Again, not that simple. not that simple. These are about to go away. This administration is not going to stand for that. Here is where they'll be able to take it away because, for example, sex ed, what is being said now is if you miss the sex ed class, you may be encouraging, the student may be encouraging the spread of AIDS. Therefore, it could present a substantive risk to the state. Therefore, you have to have the sex ed class. And the heck with your rights on moral or religious objections. But rapidly changing in these areas, yes. So, you as a student, or the students could object, or their families. I had a girl in my homeroom one year that never ever stood for the flag ever. I have no idea why. I never asked her. When we stood every morning, the other 1,000 of us to say the flag, she never stood up, and I never asked her why, and she never stood once the entire school year. I don't know. I didn't want to open that can of worms or the Pandora's box. I just said my pledge and let it go on. So they can object on the freedom of conscience. Oh, here's a better one. Search and seizure in lots and lots and lots and lots of cases in school on the Fourth Amendment. Is it unreasonable is what you would ask. Two principles. You know what they are if you've ever seen a crime show. Two principles, probable cause and reasonable suspicion. Okay, this one it has to be sufficiently convincing, and this one's a little bit less stringent in reasonable suspicion. So we don't go searching, let's just see what's in their locker. No, you have to have, this goes back to their rights, probable cause and reasonable suspicion, just like a policeman does to stop your car. Just because you're driving a yellow car isn't reason enough. Now, you know that they can find reasons to stop you. I had a brother who used to drive a pickup that was really loud and sat way up in the air, and they stopped him just to look at his tail lights or to measure his bumper. They harassed him all the time and wrote him tickets all the time, and I said, don't be a dork, get rid of it, But they could find reasons to stop him. They can find probable cause and reasonable suspicion if they want. But in schools, the same can be said. I remember the thing that we used was the dogs. The dogs would mark lockers when I was teaching the middle school, and if they marked the locker, we opened it. Okay. The expectation. Another one is the expectation of privacy, that potential intrusiveness of that search. Is your expectation of privacy the same in a purse as it is in the locker or in a desk? So here's the 4 basic search questions that you would ask before you would search anything. Does the target of the search warrant the authorization of a search? Is a school in danger if you find this? What does that mean? Teacher, I think he took my pencil. Gee, I've got reasonable suspicion here, and those types of things. But is the school in danger because of this pencil? And in your world, for the most part, this is what you'll be targeted with. Not looking for marijuana or guns, but a quarter or a pencil or my book or my cap or those types of things. And I'm telling you, you'll get mucked down with this. It'll be hard to understand and where to stand on this. Here's the next one. How reliable is that information? Like an anonymous caller, certainly less than an eyewitness. What is the nature of the search area? School officials must consider the expectation of privacy. Like say something, closer to the body, you have more expectation of privacy. Pockets and purses than compared to, lockers and desks have a lot less expectation of privacy, of course. And does the proposed search involve the search of an individual or a schoolroom? If the individual is to be searched, probable cause is mandatory, but best if never be the body or clothes. Lockers, desks, cars, that's another question. We're finding now all kinds of cases where you have cars, you have no right to protect the cars. That if they think there's something in the car, they can open it. Saying locker and desk. So again, let me give you this as a teacher, as a future teacher. This has nothing to do with you. If you ever get in this area, get somebody else. This is an area for a principal, or now most of our schools have the school resource officers or the policemen right on deck. This becomes their thing. So this isn't you. This is for your information. But this if you've got to get into this thing of searching clothes, lockers, desks, cars, you need to pass this to somebody else. As a teacher, you don't want to go here. Here's a landmark case. It's very interesting, and it'll have things for you. Landmark case of New Jersey versus TLO in 1985 focused on several issues relating to school searches. In this case, a female teacher entered a girl's restroom and found TLO and another girl holding lighted cigarettes. So they were having a marijuana. They were having a Marlboro in the bathroom, in the girl's restroom. Teacher walks in. Now, let me tell you what about this is you're going to walk into things like this, and I had this in my teaching career. You walk in and you see things, and you got to do something about it. You don't have a right not to. If this is you, you don't get to say, "Oh, I didn't see it." You have to deal with it. And I had smoking things and drinking things and just bizarre things like that. And what really made it hard for me is often they were kids that I really liked and I thought a lot of, and now you've got to kill them. You need to lower the boom. So because smoking was against the law, school rules. Now, I wonder if the kids knew that smoking was against the rules. Well, we'll just assume they did. She took both girls to the school office. When TLO was asked to open her purse, she did so. Her open purse revealed, what do you suppose? Additional cigarettes. Uh-oh. And drug paraphernalia. Uh-oh. And other evidence suggesting she was engaged in selling drugs. Uh-oh. TLO claimed that the evidence could not be used against her because her purse was searched illegally. I wonder if it was. It's kind of like back in the Supreme Court. It's kind of like back there with Tinker versus Des Moines. You know, the Supreme Court heard it like 4 years later. The kids were long, long gone, but it becomes not about the kids. It becomes about the principal. Well, same here. The Supreme Court ruled in favor of the school, rejecting that argument that probable cause was required to initiate this kind of search. Okay, get it? She says, they opened my purse to find cigarettes, and they found all this other stuff. I was illegally searched. Court says, not. In their decision, the justice argued that school officials met the standard of reasonable suspicion, and this legal standard was sufficient in the case at issue involved in a potential violation of either school rule or statute of law. Because TLO was observed smoking, a clear violation of the school rule, school officials were deemed to have sufficient legal grounds for their search. The fact that cigarettes were easily observed in her purse provided additional justification for the search. This is page 322. Okay? So, reasonable. You're smoking, we get to look in your purse. Normally, the purse is, that's one of those that I have a different expectation of privacy. Okay? Again, this teacher does the right thing. We go to the office, and now I pass this off somebody else. Now, not that I disappear, but I say this is where you ask for the school resource office. Certainly, the principal or somebody else handles this now. And you're really, really careful here when you go cross-gender, men teachers, women, female students, female teachers, guy students. That all gets real complicated. Be really, really careful in that area. So how about these family rights and privacy? Well, it's FERPA. Here's another thing that you'll want to know. Someday for an interview or a test question is, what is FERPA? Well, FERPA is the Family Education Rights Privacy Act. Well, what does that mean? Well, parents and learners over 18 have the right to view all records at any time. What? All records at any time. That doesn't mean just the ones in that file drawer locked back in the counselor's office. This means if you keep a few notes on your desk, they are entitled to look at those anytime. So just be a little careful. I learned this in special ed. We always had what we called a working file of each student that we're responsible for, and kept that at our desks, not in the permanent records, and only to find that parents at any time can have access to that. Okay, so be aware. And parents must give permission to release anything. Come on, this really came out of the thing of military wanted to look at records and say, if the student is under 18, the parents have to have permission to release records to any place. And normally what you do now is release them to an agency or to the next school or something like that. You sign. Files can be challenged, progress charts, teacher notes, etc. Yeah, did you know that the parents can challenge your findings and stuff. So be very careful what you write on records and notes. You want to keep good, solid notes and stuff, but just have a good reason for it other than gossip or meanness or mad or something like that. This here is a little misleading. Over 18, parents have right any time, but once a student is 18, they can have right to their record at any time. But before, when the student is 3, parents can still have rights to their records at any time, 3 to 18 and beyond. Okay. When it comes to college, you realize this goes away. Now they have to have your permission. I've had some dealings with that. You should also be sensitive to other, more subtle ways that learners' privacies might be compromised. Such things as plotting learners' progress on charts that can be viewed by others can be a violation of privacy. Now that's interesting, isn't it? Because I have observed teachers that did that, and let the students plot their own chart. Next time I came there, it was all gone. Teachers said, no, they told me I couldn't do that anymore. You need to handle learners' papers carefully and discreetly so others do not have access to them. And this has become more and more. It used to be, when I was in school, maybe you had this, that you not only corrected somebody else's paper, but then you called out the grades in a public forum so the teacher could record the grades. Yikes. Faculty lounges are notorious as places where teachers complain about learners and even parents. You need to guard against this practice. You may find yourself involved in a legal action if parents or guardians suspect you have knowingly spread false gossip and harms child reputation. Now, folks, you don't want this to be you. You want to stay 10,000 miles from this. I've had to reprimand student teachers that couldn't get this through their head. That you go someplace to a room or a faculty lounge or something, and they're harping on a student, doesn't give you permission to join in. Just be very careful. This is the definition, I think, of professionalism. Professionalism. Well, what about these rights of learners with disabilities? Well, challenged in 1975, changed in 1975, 94-142. Now, does anybody remember this? What PL 94-142 stands for? From the United States Congress? Yes, Public Law 94-142 means the 94th Congress, the 142nd piece of legislation they passed. There. Now, little social studies lessons for you in the foundations class. Now, all have a right to school and can't be suspended or expelled without hearing, and this is a special right that kids with disabilities enjoy. You realize you can suspend or expel other kids without a hearing? That they can request it, but you cannot do that with kids? This group is a protected group. This group, unlike so many others, enjoy some special privileges the other kids don't. Here's one. Schools must pay the lawyers if they're wrong. If there's a lawsuit and the school is found against the school has to pay for the lawyer. If you can maybe change a placement. If you're going to need to suspend a kid, say for example they bring drugs or weapons in and we have zero tolerance, they can be removed from school, but you have to change their placement. Then now they may have school in a special agency or someplace else, but they can't be just expelled. You would change that placement. And then the other thing that changed with the rights they have is any related services they need. If they need special travel to get to school or to agency or to work or something, if they need special hearing aids, if they need special training, medical service, all those what we call related services, the school may have to pay for so they can access the curriculum and the school. They're called related services. As I say, this group with disabilities enjoy special privileges the others do not. How about this one? This is off your notes, but I couldn't pass this up. Compulsory community service. This is new, and I don't know what to think of this. An emerging issue related to student rights involves compulsory community service. Many school districts across the country have implemented programs that require a certain number of hours of community service without pay as requirements for graduation. Schools justify these requirements as important components in applying school learning and developing and understanding the responsibility of citizenship. However, some students and parents have protested these requirements, claiming that they violate the involuntary servitude prohibitions of the 13th Amendment. Some have claimed that the rights of parents to exempt their children from education requirements to which they object on a basis of protesting community service activities. To date, these protests have not been successful. The courts have ruled that as long as these service requirements meet the tests of having an educational purpose and addressing legitimate state interests, and there it is again, because this is how things are changing, as long as we say it's in the state's interests, such as development of citizenship responsibilities, they are permissible. Very interesting, and again, I think, at least in my world, is this is my job to teach my kids. This is my job. We do service learning. We do service things. We do a lot of volunteer work. It's important to us. It it kills me to think now the school has to do this part for the parents also. And this new administration is 150% behind this. At the college level, there's all kinds of money available to make this happen. I don't know. The state's going to raise our children, and this is another step. But I don't know. I'm kind of old-fashioned. I get agitated easier than I should. But read about this, page 325. Okay. How about this? Why don't you respond to this here? This would be number 5. Compulsory immunity service has been on the rise in my schools. Do you think it should be permissible? How would you do it? You write a little bit how you would have, what kind of community service you'd build into your curriculum, because it has to be part of the curriculum. Okay. I'm going to take a break here and be back. You shut this off and take 5 here, because this is the next part about teachers' rights. Okay, I'm back. How about teachers' rights? What are the legal rights and responsibilities of teachers? We'll talk about teacher certification, employment contracts, continuing ed and tenure, general teachers' rights, and teacher obligations. Let's get at it. Constitutional provisions does not mention education. Do you know that? That's so interesting that the federal government wants to be involved in education. There is absolutely nothing in the Constitution about things. It was all to the states. The states did it. This is another one thing. Hey, if we're going to have a revolution, it won't be about slavery this time. It'll still be about states' rights like it was when Abraham Lincoln was in there, because the federal government is taking over the states' rights to provide education. The states were responsible for all the educational code. Federal government is involved in disputes. And that was in the courts. Several layers, depends on that type of case. Very different from state to state what they'll do. Sources of laws relating to education, well, there's that written constitution plus amendments, and that's that highest legal standard. And then there's statute law, and that's from the state education codes and state certification requirements. These are elected people. And then there is administrative law. This kind of operationalizes statutes and interprets rules, policies. And what's interesting is this one has as much power as any, because, well, I know this, legislatures often pass laws, and then there's a whole nother body that gets to interpret them and tell them what it means. Very interesting, because this becomes more powerful than the law. And then, of course, the court decisions. The ultimate check of schools applies constitutional law to statutes and administrative law. So what about certification? Well, each state has their own requirements and may accept from other states. We obviously do here, and issued by the state, not by the university. Did you know that? We at DSU do not issue these. We give recommendation to the state. We certify that you complete requirements for an education program, but each state issues certification. Okay, must have certificate to accept contract and the presumption of competence. And this is interesting because we have to have faith. If I'm the school and I'm hiring somebody, I have to have faith in this university and this state that when you come to me with a teacher certificate, that you are a competent teacher. That's the presumption. Okay. Must stay current after accepting. Right now our code is you have to have 6 additional educational credits every 5 years. Did you know that? That you have to stay current. Right now it's 6 and 5. and then you reapply, and every 5 years, and they send you a new certificate. And without a certificate, a teacher can be considered a volunteer and not paid in monetary units. Now, the only time this really gets into the way is if you have something that's not completed. I know I started out, I didn't have my certificate yet, and they said, gee, we'll hold your first check till you get it. You show it to them. But other states, for example, if you come to South Dakota, here's one of our quirks. We'll accept from any other state, but you must come here and take a course in History of South Dakota Indians, which is, is part of our curriculum. But if you're coming here from any other state, you must have that, not a course in History of Indians. It has to be South Dakota Indians. Now, you go to any other state too, they'll have a little quirk someplace of something you may need, and generally you get 2 or 3 years to get that course taken. Teacher certification. How do you gain employment? Well, state and federal law govern that process and screening. Questions asked of applicants must have a demonstrated relationship to a job. And it's just like any other job. It's not just teaching. This applies to all jobs. Most states have laws that restrict the school personnel can ask a teacher candidates during interviews, like, are you expecting? Some are cause these questions can be asked, like your marital status, pregnancy age, religious preference, sex, race, national origin. Did you know this? Some laws apply to public as well as private educational institutions. Okay. Others apply to just public. Here's the private one. This is very complex. A private religious school can legally give preference to an individual with particular religious affiliation if such affiliation is required for school to fulfill its mission statement. Now, take this how you will. In our school, my kids go to a small private Christian school, and at our school, you have to declare that you are a born-again Christian to teach there. That is one of our requirements to meet our school and fulfill our mission. Okay, so we can discriminate based on that, not on these other things, not on these things, but on this we can. And so that's very interesting. Now, this is another one I think will go away. I think the current administration will do away with this, and they will say that's a risk to the state. And I think there will be war declared on these things, just as it will homeschool for the same reason. But right now, as it stands, they allow religious schools, private schools, to discriminate if it has something to do with fulfilling their mission. Okay, how about teacher contracts? It's the most important document. It sets responsibilities. Sign only one. It must be written and approved by the board. You know that the principal or the superintendent may interview you and offer it, but the school board must approve it. You're not hired, you're not official until the board approves it. And it has benefits and bonuses and extra duties. How about breaking a contract? Yikes, I've had some trouble with this in my life. Good for only 1 year at a time. You have to have one each time. Teacher may be dismissed without explanation in that year. Often part of probation. Some from state to state, districts to districts have that. Tenure gives teachers, you ever hear that term? Been lots of talk about that. Tenure gives teachers employment rights that cannot be altered at the whim of school officials. School must prove tenure came without school must prove that there's something wrong. Tenure came about to protect teachers from groups who wish to fire them because of differences in what should be taught in the classroom. I always thought tenure was mostly to protect the coach. A group of parents that my kid's not playing enough, it's a bad coach is the problem. More so than ever. It's supposed to keep good teachers in the same school. Granted, after 3 years, you would have tenure. And the only thing once you're having tenure, you can still be fired. It's just that you have to now you give them due process if they want it. Okay, so after 3 years, you can be granted tenure. You can dismiss without cause really before that. To me, the biggest group in this was the coaches and it's really, the coaching thing is a whole new level than what it used to be. Do tenure programs keep bad teachers in school systems also? Ooh, this is the one that nobody likes to talk about. A California case several years ago found that it took 8 years and $300,000 to fire a tenured teacher, a bad tenured teacher. And that's what a lot of criticism over the years, that we give teachers tenure and then we can never get rid of them. This administration is talking about this. It'll be interesting to see where it goes. The current presidential administration saying that he's for getting rid of bad teachers, and of course he has a big constituency that doesn't like that. So here's 6 ways you could lose your job and be well documented. First of all, it's incompetence. Includes lack of knowledge, failure to adapt to new teaching methods, violation of school rules, persistent negligence. If you're incompetent, because remember, we assume competence when you come. And, if you have lack of knowledge or, teaching methods, violation of school rules. Okay. How about incapacity? Like you have a physical or mental condition that keeps a teacher from performing assigned duties. And that gets real interesting also because we have some screenings, but what if you develop mental illness? What's the screen, or how do we catch that, or what do we do about it before you do damage? This one's a little more tricky. Okay, and then, insubordination. You have a willful violation of reasonable school rules and policies. Oh, this is, you're asked to do something, you don't do it. You're insubordinate. Part of your job is to do bus duty, and then when you refuse to do it, that's insubordination. How about conduct? Insulting fellow teachers, taking time off without permission, drinking to excess, and even telling wrestlers to lie about their weights when registering for meets. Yikes. And how about immorality? This one has really gotten tough. Criminal activity, yes, but sexual misconduct, drug use, dishonesty. Let me tell you this, criminal activity, and often before there's even a hearing, you can be put on leave. Sexual misconduct, mostly teacher to student, very rarely adult to adult, because it used to be big. Now it'd have to be some pretty remote areas where you're having a relationship with a married person in the school. I know of examples where neither of them lost their job. They both lost their spouses, but neither lost their job. Drug use was a thing here some years ago where a lady that taught in the school, her son had illegal drug activity in their house, and she lost her job because her adult son was dealing drugs out of her house. That was a sting. And any kind of dishonesty could be. And then other causes like impertinence, intemperance, neglect of duty, cruelty, willful misconduct, those kinds of things. And must be given due process for any of these. Remember due process? Which right are you being denied? You have a right to know who the accuser is. You have a right to defend yourself with a lawyer. You need, those types of things. So here's some general teacher rights. You have academic freedom and freedom of religion and teachers' freedom and lifestyles outside of school. So let's look at this one, that academic freedom. The idea is that teachers and learners should be able to inquire about any topic, even one that's highly controversial. And we have a few of those now, more than we did in the past. In the past, I felt anyway that we were more like-minded. We were more homogeneous sense of community, that we thought alike, and I find today that is extremely not true. Often great conflict between adopted curriculum and the teacher's rights. Like courts generally support the teacher's rights. So if you have some objection, the courts have usually said, like if you don't want to teach about AIDS or evolution or some of those things, generally the courts have sided with you. Have to be able to defend, why you're doing something. So the school board has a right to prohibit certain texts or materials. Not all look at academic freedom as a positive thing. Like who decides? Who gets to decide this? Like on birth control, religious beliefs, army recruiters. And this one you don't hear so much anymore, but this was back from Tinker, that there was big stands. No recruiters in our schools. Okay. And again, religious beliefs, you go, what's that? But boy, oh boy, I'm telling you, we've gotten pretty extreme. And I think one of the most extreme now is no religion. And we're still a little sheltered here in South Dakota, but I assure you, in your time teaching, this will become more and more and more religious beliefs. And birth control will be more and more accepted, that we still kind of flinch when we pass out the birth control, but I assure you, in time, we will dispense this like we do Coca-Cola. And expect people to use it like we do Coca-Cola. How about this? Academic freedom you enjoy as a teacher does not give you the right to ignore the course of study of the subject you teach. Material included in the classroom must be relevant to the course and appropriate for the age and maturity of the learners. And again, we're going to assume you know what that is. You might be interested in knowing that teachers have lost academic freedom cases in situations such as the following. Teacher continued to teach sex-related content in a health class because he believed it was high interest to the learners. Well, I wonder if learners would have a high interest in sex-related content. Teacher showed an R-rated film to 9th through 11th grade students on a non-academic day. And all I can say to you, always err on the side of safe. Don't show anything. If you have any question at all about it, don't do it. Don't be the teacher that's apologizing for behavior. First year I taught, we showed a movie at Christmas time that had a nude scene in it. And when the nude scene, that was, it used to be a reel-to-reel, the guy in charge of the student council showing it, he just stood in front of the projector so they couldn't see the nude scene. Now, every student in the place had seen it. Every student knew what it was. I thought the guy should have been fired. He thought it was hilarious. That was big talk. I'm going to say to you, I never want to be that guy that's accused of this. Please, students, if you're going to be teachers, live above reproach, not just in this area, but in all areas of your life. I'll talk more about that later. How about the math teacher encouraged learners to protest the presence of military recruiters on campus? The teacher said protest. Now, all of these should be fired, I think, but I'm conservative. Oh, grading. This is a big one. Oh, please understand grading. Courts find teachers qualified to assess grades, and we do too. We assume you're competent when you leave us. Even though we don't teach you about grading at the university level, how many courses have you had on grading? Yeah. One of the daunting things I had when I started teaching 25 years ago was writing tests and grading, how to grade stuff. Courts are reluctant to overturn teachers' grading decisions. Thank you, courts. But to avoid arbitrary grading, have a clear grading scale, keep accurate records, and do not lower grades as punishment for non-academic behavior. I had this happen one time. I wish I'd known my rights. I had to challenge the guy, but he gave me a test back that had like a very, very bad grade. And so we went through the test, and many, many things he'd counted wrong on mine that were right. And so finally, after I kept bringing this up for him, he finally said to me, well, could it be that when I was grading your test, you were talking when you weren't supposed to be? He violated this one. He was a very bad man. And how about freedom of religion? Well, teachers have the right to not participate in the Pledge of Allegiance. Please don't do that. Please participate, but you have the right not to. Districts may impose a dress code that prohibits specific religious dress. Why? Because it'd be disruptive. Teachers may have leave for religious holidays if they meet two conditions. First, the teacher's absence cannot create an undue hardship on the school, like on a small school, and the amount of time taken off cannot be excessive. Okay. Here's what's interesting about this. For the most part, still in our country, our schools are built on Christian, Judeo-Christian things like Christmas, Easter, those types of things off. Now, I assure you those are leaving. Already in almost most universities in our country, away from here, there's no longer a Christmas holiday at all. It's a winter break, winter holiday. And with that, there's absolutely, my brother went to University of Iowa, no Christmas trees, no mention of anything Christmas. It was winter break, winter holiday. And so that too will come. We're going to hit you in school with that. But if you have some other religion, I assure you it'll be much better accepted than anything Christian. So if you're Muslim or Jewish or any other thing, you are entitled to time off if it meets these two criterias for religious holidays. So how about these civil rights a teacher may have? Well, there's been many restrictions on teachers' lives away from school. There are few restrictions. There have been court cases centered on the personal rights of teachers. Okay. Used to be big that you had to be exemplary life. Some people believe that teachers are role models, so they have a responsibility to behave better than typical citizens. Do you believe that? Do you believe that? The courts have ruled that teachers cannot be punished for exercising their constitutional rights, and when teachers have been dismissed because of actions in their personal life, the school district had to present convincing evidence that the behavior was having a negative impact on their performance in the classroom. And so that's really become the litmus test. If they can't prove, you can get away with just about anything if it doesn't affect your thing in the classroom. One exception to teachers' rights is when they work in religious settings. Church that controls a school has a right to discriminate on the basis of marital status, family parental status, sexual orientation, race, religion. Discrimination is essential for the maintenance of the religious ethos of the institution and is responsible in order to avoid offending religious sensitives of its members. So again, the private schools now enjoy some freedoms that I think will go away. These are going to be taken away. How about lifestyle issues like sexual orientation, unmarried cohabitation, adultery, use of vulgar language, even breastfeeding in school? Now sexual orientation is not enough, or public flaunting of unconventional sexual conduct. Situation-specific court size, sophistication, community values, reactions. I say in some communities it's different, and the courts still allow for some of that based on your community values. How would this be viewed? Okay. How about immoral? When relationships with learners, always dismissal. Okay, we've come a long way, baby, but this is one yet we're still not too good with this teacher-to-learner relationships. Okay, so just know that. Courts have acted in support of dismissal decisions, and that's what I would suggest, that if there's any question about this, that you're dismissed if you have any kind of a inappropriate relationship. And I don't think we need to ask a lot of questions. Sorry about your rights, but if you're messing around with one of the students, you should be gone. Courts look at the teacher's behavior and how it influenced both his or her standing in the community. If their actions are outrage the community will lead to dismissals. Yes, and teachers have been involved with other adults are not as likely to be dismissed. And I say that we've slipped on this a little bit. And again, let me give you this thing here, folks. Don't go here. Don't live an exemplary life. If you want to be a teacher, if you can't live above reproach, please go into another field. If you're going to be a teacher, you may not teach my kids, but you're going to teach somebody's kids. And not only in this area of immoral conduct, but in all things. If you need to drink, if you need to do smoke pot, if you need to do these kinds of things and exercise your rights, by all means do, but do it in another profession. We don't have much left for role models for kids. Well, let's try and have them be teachers. If you need to have inappropriate sexual relationships, please go do something else for a living. This is the one thing I ask from you as a teacher. If you're a tippler, if you're somebody that thinks it's hilarious to be drunk, and I get to see this. I've got people in my classes that are friends of mine on Facebook, and oh my goodness sakes, I'm terrified of what they'll be as teachers. Please, and again, I say teacher to learner to learner, or teacher to learner. There's no excuse, but what you do, how you avoid this with students, and people think this is hilarious, but you head this off with teacher to learner relationships way back when that student starts hanging around when they shouldn't be. You can't stop this once you're alone and the windows are all steamed up and stuff. Stop. And it used to be just men, and of course now the media is full of women teachers having inappropriate relationships with young men, young boys, and stuff like that. So stay clear of this, and if you get involved with this someday and I hear about it, I'm coming to kick your butt. I mean, because this is ridiculous. Just live above reproach if you're going to be a teacher, please. Criminal conduct or even conviction or even indictment can be grounds for dismissal or certainly suspension. Now you do have to do this. You have to reveal any convictions before we allow you into the teacher's ed. Shoplifting. The most common one I get from you all is that you have to declare as you have open container. Why is it you all got to have open container when you're in high school? You're not old enough. Hey, put the beer away. Leave it alone. Get to write that down. I can't tell you how many sit in my house. I had open container in high school. Well, hello. Preponderance of evidence is all that is needed, and revocation of certification is not as strict. It takes more to yank yours. Student to learner relationships will yank your certificate, but some other convictions don't necessarily lose your certificate, but certainly your job. And you don't need a court of law before you lose your job now. And this reporting of child abuse, a teacher is in a position where they can spot young people who have been abused. All 50 states and District of Columbia have laws that make mandatory reporting of this. Mandatory reporting of suspected incident of child abuse. Now that sounds obvious, but believe me, it's not. As a result of teacher being in the position of spotting it, they are designated mandatory reporters. Teachers have a legal obligation to report any given instance of suspected child abuse. What does that look like? If any suspected case are not reported, teacher may face up to 6 months in jail and or $1,000 fine. Did you hear me? 6 months in jail or $1,000 fine. Now, not too much of this is prosecuted, but if a court found that you knowingly did this, that could be. Teachers need not to fear retribution as a consequence of reporting potential child abuse, and all states provide some type of protection from lawsuits for reports of child abuse. Many states include a provision to pay for an attorney for a suit filed against a teacher for reporting this. Seems simple? Believe me, it's not. In most cases of reporting child abuse, teacher reporting the case will not have her name go public. Teachers may not be disciplined by employer for reporting suspected abuse unless it's reported for malicious reasons. Then we kill you. And according to the Prevent Child Abuse website, each year over 3 million cases of child abuse are reported. That's a lot. Okay. Let me just say one more thing about this. The hardest one of child abuse for you to report, and I dealt with this too many times, is neglect. The thing with neglect that makes it so hard is it's varying degrees. And where I thought it was neglect is when these kids would be dirty, unclean, smelly, tired, unfed kids. Only to realize that these kids were living in places where the parents were functioning the same way, and so it's hard. So let's look at these things. What is negligence? Is the failure to use reasonable care to prevent harm from coming to someone. If someone can be found guilty of negligence without intending to inflict harm, like gross negligence is an act of reckless disregard of the consequences affecting the life or property of another. 3 kinds of negligence. First, misfeasance. Teacher acts unwisely or without taking proper safeguards. And then there's nonfeasance, a failure to act when there is a duty to do so, and malfeasance, behavior that is undertaken deliberately and knowingly to harm another. Okay, so this one's easy. Malfeasance, you deliberately do something. Please get to know these two. The teacher acts unwisely. Here, failure to act. Okay, there's some tests on the question. There's some questions on the tests about these. How do you protect yourself? Well, you have a basic understanding of what creates liability. You foresee and prevent the conditions for which they rise to injury, and keep informed of specific ways to avoid liabilities and other operations. Join groups promoting safety. And here's some additional findings of Fegans. Tort liability. You know what tort is? It's a civil wrongdoing, not criminal, meaning you're not arrested. Somebody sues you. Involved in injury against another person that resulted from a breach of legal duty. Say, for example, you're supposed to have recess duty and you don't get out there and the kid gets hurt. They may not arrest you, but somebody could sue you. That'd be a tort. Torts are settled with some kind of award, and generally it's money. Torts against teachers have been increasing in numbers for not doing their jobs. Tort laws are based on common law and the concept of fault or intent, and that's what we do. We have to assign fault to accidents, and that's what we're such a legal happy society now, that nothing is an accident, everything is somebody's fault. So if there's an accident in your school, no, then we're going to try and find somebody to say it's their fault. Tort cases finding do not need to prove fault beyond a reasonable doubt. Questions that are relative to injury-related suits against teachers include: did the teacher have a duty to care under the law? If so, was the duty breached? If a breach of legal duty occurred, was it in the proximate cause of the injury? Okay, so these are the questions for tort injury. Injury is huge. Injury is almost one always in school that heads are going to roll. There's going to be some consequences, just like car accidents. It's just an accident until somebody's hurt. Now somebody's got to be sued, kind of thing. Force and discipline. This might not come in. Ingram versus Wright can use reasonable but not excessive force. Can you believe that in discipline? What is reasonable? Well, like how severe is the force? What's the age of that person that you're punishing? The gender and your size compared to them, and how mad are your attitude? Is how mad are you? Okay, so if you're really mad, you're out of control. State and local regulations decided by locals. You have strict guidelines. Legal actions is not protected. How about malpractice in school? Conditions that might lead to malpractice, like a failure to bring achievement up to satisfactory level. This is different than negligence. Now we're in malpractice. Injury to the development of the learner. Failure to act to protect a seriously threatened learner. Yeah, they're threatened and you don't do something about it. That's malpractice. How about slander and libel? Does not have to be a physical harm. The false statements that expose a student to contempt, ridicule, or disgrace may harm. Yeah, you know what? True statements may also be in here. So you now have a right. Spoken is one thing. Written is called what? Well, spoken is called slander, and libel is written. Karen writing comments, only observation. This person is a thief. Whoops. That is a slanderous thing. If malicious intent, are you doing this to, with malicious intent? And sexual harassment, more litigations than ever. Karen working with learners outside of class or school. School can be held if notified. It also can be held if learner-to-learner case, and cannot be ignored anymore. Now let me tell you what this means. Outside of class or school is where you really be careful, and this is you coaches and anybody. This is where lots of trouble comes in working with these, but this is where these relationships, but here, this is even learner to learner is a problem now, and that is student to student. So here's where this gets a little murky. We're in 7th grade. Teacher, that girl or that boy said I was a slut. Okay, I do nothing about it. Okay, next thing, he's bothering me. I do nothing. I don't take any case here. The next thing you know, there's a problem, and they go to the principal, the parents, to the school, and here we find out that they've been telling you. The student has been telling you that this other person was bothering them, harassing them. Okay, and so this is that learner-to-learner thing. I mean, I don't need to tell you about teacher to learner or teacher to teacher, but let's talk about learner to learner. So you can't ignore this anymore. And here's what I would do if I were you. As soon as you hear this, whether you're in high school or in 7th grade, is I would get up on your soapbox and give a speech about how you can't ignore this, and that you must report it, and give them a chance to recant this. But you need to tell somebody. If you hear this, you need to tell somebody, because when it becomes a problem and you had knowledge of this and did nothing, you are liable, and your school is. And there's more litigations than ever. And it used to be, here was a common one, is pull the little girl's brassiere strap. Okay, I'm telling you, that is the sexual harassment. And if you have knowledge of this and do nothing, and if nothing else, I would get in their face. I would get on my soapbox. I would preach about this type of thing. Okay, here's the summary. It's very good. Okay, there's your misfeasance. Okay. And then we'll make this, I think we're up to about, 5, 6, and 7. And there's some stuff beyond this on your notes that you need to do. There you have it, teachers' rights.